Broadcast is now starting. All attendees are in listen-only mode.
Well, good afternoon, ladies and gentlemen, and welcome to the latest in our series of People Hour webinars. My name's Simon Horsfield, and I'm going to be presenting today on responding to equal pay queries and defending equal pay claims. Before we start the presentation, just the usual housekeeping. Just to remind you that on your dashboard you do have the facility to ask questions as the presentation goes along, so please do use that facility. I suggest though that we will leave responding to those questions until the end of the presentation, simply because it's quite a complex topic and we just need to keep the flow of the slides going, if that's okay. Second point to mention is that, as with all other webinars that gunnercooke run, this will be available on our website. So if any of your colleagues aren't able to attend, or you think that having heard this presentation they should also hear it, by all means send them the link. So on that note, we will start the presentation. And just to say, why are we focusing on equal pay at the moment? And it's because of that overlap with the gender pay gap. And I'm sure you've experienced this. It's certainly my experience from speaking to a number of clients that I work with, that a consequence of gender pay gap reporting hitting the news has been very much probably foreseeable, that people have started to ask questions about their own pay, and particularly females within the organisation have started to ask themselves, am I being paid a fair amount for the work that I do? Am I being paid as much as my male colleague? And whilst, of course, equal pay and gender pay are fundamentally different concepts, that doesn't stop the media talking about them as if they are one and the same thing, and it doesn't stop people drawing that same conclusion. But just so that we're all clear at the start of this presentation, when we talk about equal pay, we are talking about principles involving a specific claimant. And remember, that can be a man or a woman. We tend to think of it in terms of a claim that women bring, but remember, it's just as much a right for a man to claim equal pay as it is for a woman. And they compare themselves with a specific comparator who they say is doing equal work to them. So it works on a very much an individual basis. Contrast that with gender pay and gender pay gap reporting, and that really is just a representative figure based on the average hourly pay of males and females within the organisation. So it doesn't tell anybody on an individual basis where they're at and how they compare with their colleagues. And maybe that's an important message to say right at the start, to the extent that people are starting to query within your organisation whether they're being treated fairly in terms of pay. Maybe just explaining that difference will be enough to put people at ease. And remember, you can have a significant pay gap within your organisation without there being any breach of the equal pay legislation. And of course, that was the conclusion that was reached when one of the big four came in and audited the BBC's pay structures, and they concluded in their report that there was no inequality in pay for the purposes of equal pay. Whether you believe that or not is another matter, but it just illustrates the point that you don't necessarily have to be breaching equal pay for there to be a significant gender pay gap. But that said, and it's an obvious point, the pay gap can be worsened. You can exacerbate it if you have pay inequality within your organisation. And I know we'll come on to this, but a lot of organisations, as a result of going through the process of gender pay gap reporting, are now starting to think about whether a sensible response is an equal pay audit. And we'll conclude with some thoughts about that later. Now, despite them being different concepts, there is still this definite increase that I've already mentioned in terms of equal pay questions, which are maturing into equal pay grievances and ultimately claims as a result of these gender pay issues hitting the headlines. So very much the thinking behind this webinar is that forewarned is forearmed, and let's start to think about how we would respond to those questions if we face them in our day job. So let's just have a quick summary of the equal pay law as it stands. And the principle is very simple. Men and women should receive equal pay for equal work. And equal work, there are three types that you can hang your hat on if you want to bring a claim. There is like work, there is work rated as equivalent, and there is work of equal value. And we'll look at each one of those in a little bit more detail shortly. But having established this principle of equal pay for equal work, we've got to think about what's the mechanism for achieving that. And the way it works is the legislation implies a sex equality clause into everybody's contract of employment. And because it's a clause that's implied into the contract of employment, that means that only contractual issues are covered by equal pay claims. If you're talking about a discretionary benefit or a discretionary bonus, for example, then that's outside the scope of an equal pay claim, because equal pay claims only cover contractual matters. So discretionary claims of that nature would have to be brought under the discrimination legislation, sex discrimination principally. And the sex equality clause that's implied into the contract is defeated, so it doesn't operate if you as the employer have a material factor defence which explains away the pay differential. And again, we'll be looking at this material factor defence because it's a very important part of the equal pay legislation, and we'll be looking at it shortly. Just a reminder that the legislation specifically protects women on maternity leave in the sense that if their colleagues receive a pay rise whilst they're on maternity leave, then the legislation provides that they should also receive that pay rise. And if bonuses are paid, and these are contractual bonuses, then the woman on maternity leave should get the pro rata amount of that bonus in relation to the non-maternity leave period. And typically, equal pay claims are enforced in the employment tribunals. We do see claims, and in fact I have a claim ongoing at the moment in the county court, but ultimately, even if you issue in the county court, what's happened in the case I'm running is that the county court said, we don't want anything to do with this, the tribunal's better equipped, and so they've transferred the case to the employment tribunal anyway. Now, in terms of pay differentials, it's important to remember that we look at the individual items or terms of a person's contract of employment when determining whether there's been less favourable treatment and therefore that sex equality clause has been breached. So this requires this term-by-term approach, not a shopping basket approach where you value the package as a whole. In order to make out the claim, it's important to bear in mind that the claimant has to be able to point to a specific comparator. And that comparator obviously must be of the opposite sex. They can be a current or a previous employee, but not a successor. They have to be working in the same employment, which we'll come on to in a moment. And they must be an actual person. You can't have a hypothetical comparator. And of course, in the other discrimination arenas, hypothetical comparators are allowed, but that's not the case with equal pay. So remember, the individuals who are seeking to draw a comparison with somebody else, they must be in the same employment. And that means the comparator has to be employed by the same employer or an associated employer, so that would cover group company comparisons, either at the same establishment, which is generally interpreted as meaning the same physical site, or you can have cross-site comparisons, so comparisons across different establishments, but only if common terms apply either common terms on a site-by-site basis or common terms as between claimant and comparator. And we've got some examples of how the tribunals have interpreted this concept of common terms. It's been held that common terms apply where the parties are subject to the same or a broadly similar collective bargaining arrangement, or where there are otherwise significant correlations between the contracts of employment of the affected individuals, or indeed the handbooks. So in most cases, if you think about it, even in group company structures, it's often the case that people are on a uniform version of either contract of employment or more likely staff handbook, and that is generally enough to allow those comparisons to apply, even across different establishments and even across different employers within a group. Now, you'll remember we said there are 3 types of equal work, and the first type is like work. And if you like, this is the most simple of the 3 types to get your head around, because it simply means that the comparator is doing the same or broadly similar work. So any differences that you might see are not of practical importance. They are, the tribunal, when they're assessing this, would be entitled to just disregard those and say, no, essentially these are the same jobs or broadly similar jobs. And to put that in context, in the HR speak, we might have 2 HR business partners seeking to compare themselves and say that they are clearly doing the same work. We could also have an HR administrator seeking to compare themselves with a person providing administrative support to the learning and development function, for example. And that's likely to be broadly similar work. But in my speak as a lawyer, am I doing the same or broadly similar work as an employment lawyer to one of my colleagues doing corporate law, for example? And there you may have a potential hurdle to get over in convincing the tribunal that actually the differences between the type of work that we do are not of any practical importance. Okay, and remember that when looking at like work, it's not just job title that's relevant, it's job description and also what work is actually undertaken. So the tribunal will really scrutinise these issues, and ultimately it's a question of evidence, and the claimant gives evidence about what they believe their duties encompass, and the respondent gets to put forward counter evidence, and it's for the tribunal to make a finding of fact there. I've just said at the final point on that slide that we do sometimes see situations where the claimant is actually paid less than a male comparator who is doing less onerous or less skilled work than her. And I'm falling into the trap here of assuming it's a woman making a claim, and it could just as well be a man. But the point is that you can, as a claimant, compare yourself with someone doing less onerous or less skilled work if they are paid a higher rate of pay than you. So the second type of equal work is work that is rated as equivalent. And this is a very specific type of work where the employer has in place a job evaluation scheme. A number of different schemes out there. The one I'm most familiar with is the HEY job evaluation scheme, where you have jobs grouped together in the same salary band as part of a job evaluation scheme. Those jobs are rated as equivalent. So if someone from a different job family seeks to compare themselves, then they may well struggle, because they may well struggle to get past that rating as equivalent test. But if within that band you have people paid at different rates when they've already been rated as equivalent, that does leave you exposed to an equal pay claim. There may be a material factor defence, as we'll come on to, but on the face of it, you've got a difficulty to get over. So clearly, job evaluation schemes, if they are introduced, can be very useful in terms of eradicating equal pay, and it may well be something that a number of you are considering looking at within your organisation. The only point I would say, and it's, I guess, a fairly obvious point, is that introducing that scheme may well uncover existing pay inequality, which could result in potential claims for back pay. So we'll have a think about that in a bit more detail when we think about equal pay audits and the tactics around those. So then the third type of equal work is where the work is of equal value. And for the purposes of the legislation, work is of equal value if it is equal in terms of the demands made having regard to effort, skill, and decision making. And those are the only three relevant factors, but of course they are quite wide-ranging in themselves. And this will always require expert evidence. The tribunal accepts that the tribunal panel isn't qualified to make this kind of assessment, and therefore the tribunal will always appoint an independent expert to report on this issue and be guided by them in terms of reaching their ultimate finding of whether the work is of equal value or not. And of course, this requires a similar process to the job evaluation scheme, so you might get someone who's an expert in hay job evaluation schemes to come in and do that report, but the point is they will simply be focusing on the two jobs in question, not producing a scheme for the whole organisation. And it's this equal value that I think is the most difficult to deal with, and it's the one, of course, that sees successful claims from school catering staff seeking to compare themselves with refuse attendants, for example, so completely different work but of equal value. It sees the checkout staff at the supermarkets seeking to compare themselves with the warehouse staff, and so on. Okay, so if we establish that people are doing or are potentially doing equal work, is it possible to have different rates of pay for that same equal work? Well, potentially yes, because we may be able to play our material factor defence card. And this is a defence that can be run at tribunal. The onus, the burden is on the employer to make out that defence successfully. But as we said at the beginning, if they do make out that defence successfully, then there is no liability for the pay inequality. One point to make at the outset is any material factor that you rely on can't itself be tainted by discrimination. But the types of factors that have successfully been relied on in the past include past performance. So if we've got one of these claims and we've got different rates of pay, one of the questions I'd be asking is are your pay increases performance related in any respect? And if so, let's see the performance records of the individuals in question to see if we can justify the difference that way. Another factor might be length of service, the implication being that with increased service comes increased experience and therefore increased pay. And that is a potential material factor defence. The only thing I would say there is we just need to be careful with low-skilled jobs. And certainly I've experienced cases where trade unions have pushed back very hard on this point with, for example, cleaning staff on the basis that whether you've been a cleaner for a matter of months or many, many years has really no impact on your overall ability to do that job. And I'm not saying that to denigrate that job in any way. It's just a live example. And so length of service itself potentially there, but may have limiting factors. Hours of work can justify a pay differential, the most extreme example being the difference between day shift and night shift, for example. Geographic reasons, of course, could justify a difference in pay. compare the rates that you need to pay in London compared with the northeast of England, for example. You may have people doing exactly the same job, but they command a different rate of pay for that job. Pay scales, they may justify different rates in pay. That's another type of length of service criterion in many respects, but maybe adding in additional points in the pay scale for management responsibilities and so on. Market forces, where we often see market forces used as a material factor defence, is where in order to recruit somebody you always have to pay a premium, and therefore that leads to a pay differential, particularly if then year on year they're getting the standard pay increase on their originally inflated salary. So market forces tends to run that way. I've seen that run in cases involving lawyers, for example, where let's take an area of law, derivatives law, which is very much the domain of the magic circle. If as a bank you want to employ a derivatives lawyer to work in-house for you, you have to pay more to secure that person than you would pay if you wanted to recruit just a generalist corporate commercial lawyer, and that would be potentially a successful market forces defence. And then the final example that I've picked up from case law, historical reasons can lead to pay differentials. The most obvious reason of which being a TUPE transfer, for example. If you inherit staff who are on a higher rate of pay than your existing staff, then you're kind of stuck with that, because TUPE means you can't change that person's salary, or you can't do that easily. And so that can be a potential material factor defence. Just a note of warning though, it has been held that there is a shelf life to that defence, and I think this would apply in relation to your market forces defence that I mentioned as well, which is, it's all well and good at the point of transfer or at the point of recruitment that you have to pay more, but you're expected to take steps over the course of time to close that gap, which either means paying the other person more or effectively ring-fencing the better paid person's salary until levels have equalised. Okay, we'll leave material factor defence there and move on to equal pay and TUPE. Just a point to make that if an individual has been subjected to pay inequality by their previous employer and they TUPE transfer over to you, you inherit, as the receiving employer, that liability. And what that also means is that if only part of the business has transferred to you and the comparator that the individual wants to compare themselves with is still with the old employer, then you can run that comparison as well. And the time limit for bringing the claim in that scenario is 6 months from the date of transfer. And that's for the pre-transfer period. But for the post-transfer period, any pay inequality claim continues indefinitely for so long as that individual is employed by you as the new employer, and back claims limited to potentially 6 years in those circumstances. The transferring employee can compare themselves with a member of your workforce as well, so they don't have to just make a comparison with someone who came over with them or who stayed behind. They can compare themselves with a new colleague. And as we've said, potential shelf life to any material factor defence based around the historic reason of the TUPE transfer. So take steps to equalise pay sooner rather than later. Now then, what happens if an individual wishes to challenge pay inequality? And this is, I think, really where the rubber hits the road. It's all well and good knowing about the legal principles, but what do we do if somebody in the organisation puts up their hand and says, I think I'm being treated unfairly in relation to pay? Well, the first point is that there is an ACAS question and answer procedure that a claimant or complainant can follow, and that replaces the previous statutory questionnaire, but essentially provides for the same procedure for the individual to follow. What they are advised by ACAS to do is, in writing, say they think there is a pay inequality, identify their comparator or comparators, explain why they think their comparator or comparators are doing equal work, and then ask questions about how pay is determined within the organisation and how the employer seeks to justify any difference in pay. What ACAS doesn't go on to say is that you should also ask what your comparator is paid, although in my experience most individuals do, and kind of why wouldn't you at this stage? Because you do want to find out whether your suspicions are right and there is a pay inequality. Now, if one of those requests comes in, and it may look very formal and refer to the ACAS procedure, or it may be very informal and make no reference to the ACAS procedure, you as the employer should still respond in a reasonable time, and your response, according to the ACAS guidance, should either be to accept and hold your hands up and say, yes, there's a discrepancy and we will resolve this, or more likely, you will deny any liability whatsoever, and you will probably challenge the comparator that they've sought to name, and you will perhaps say that this is just a fishing expedition and for X, Y, and Z reasons these are not appropriate comparators because they are clearly not doing work of equal value or equal work, like work or work rate as equivalent for 1, 2, and 3 reasons, and or you will provide your justification for the difference. And the way these claims work, of course, we can plead when it comes to tribunal in the alternative. So we just attack any such claims in as many different ways as we can, assuming we want to defend them. An important point to make is that an employee who has asked a question about equal pay is protected from victimisation, having asked that question. So clearly we can't then treat them unfairly in terms of promotions, opportunities to training, pay rises, bonuses, and so on. So we've got to be very careful. They are protected once they've started to ask these questions. And of course, if they are dissatisfied at this point, then they may proceed to raise a formal grievance. And I've asked the question there, it's a rhetorical question really, should we try to resolve informally at this point? And I guess there are arguments going either way there. My own personal view is that if the matter proceeds to a formal grievance, there is really likely to be no winner, because either the outcome is you accept that there's pay inequality and so you have lost, or you win by denying the pay inequality and totally devaluing that individual who has raised the question about pay inequality, because essentially what you've said is you are not as good as you think you are for these reasons. And so that's why I always think these are an employee relations nightmare for you, and would always advocate, if you can, trying to resolve the matter informally as soon as you can. Now, I'm often asked the question about confidentiality, particularly in relation to that point I made earlier, which is a complainant is likely to want to know what their comparator is being paid. And I think a key point is that confidentiality itself isn't the issue, because pay isn't a confidential matter, and pay secrecy clauses are unlawful in any event. So it's perfectly permissible for individuals in the workplace to talk about what they are being paid. The real issue, though, and of course it's a particularly hot potato at the moment in the light of Friday and GDPR coming in, but it's a data protection issue, isn't it? If you are disclosing what a person is being paid, you certainly mustn't do that without the individual's consent. Of course, we've got that whole uncertainty around the validity of consent in a post-GDPR world. So what most employers do is actually hide behind data protection and say, I can't divulge this information without a tribunal order, in which case I'm in the clear because I'm disclosing that information in response to a legal obligation. But of course, even when that happens, I would still be notifying the individual that and letting them know that you are having to disclose their pay data. So, if one of these queries comes in, your next step will be investigating that pay inequality. Shameless plug here from the lawyer, consider taking legal advice. It's not just to drum up business for me, though. It is a useful point to bear in mind because, of course, if we are advising on the potential pay inequality and helping to investigate that, then any findings that we make on your behalf will be privileged, and that just gives you that bit of breathing space to decide how to deal with the outcome of the investigation. Of course, we can help you knock out potential comparators and position your material factor defence. That's all stuff you can do, but we can certainly add value there. And we can instruct remuneration consultants. If it's an equal value claim and you need to get a view from somebody on whether the jobs are of equal value, then we can do the instructions and potentially take advantage of legal privilege there if the expert is reporting to us on your behalf. If the pay inequality is accepted at this early stage, and it may be that you're just banged to rights on the issue and you realise you have to do that, or tactically you may decide you want to keep the individual if they're a valued employee, then it seems to me that the best way to deal with matters is to reach an amicable agreement and settle it by way of a settlement agreement. We will only be settling that particular claim, and we could potentially extend it to other claims as at the date of the agreement. But obviously a well-advised employee would not want to be compromising potential future claims in that scenario. In that settlement agreement, we can have a secrecy clause, so we can preserve confidentiality, but remember that would be unlawful to the extent that we sought to prevent that individual disclosing their pay in connection with any equal pay questions. So it's of slightly limited value, but still worth having in there for deterrent reasons. So, challenging pay inequality, as we've said, try and close the matter off informally before the grievance is raised. If the grievance is raised, it does need to be responded to in the normal way, and we need to think about any ACAS code implications of unreasonable delays and that kind of thing. And once employment tribunals have been commenced, remember that full disclosure rules will apply, but what we often see is that we can preserve an anonymity, given that this is, tribunals are a public hearing, by having a codified list and giving the tribunal a key so they know who we're referring to, but for the purposes of any general public who come into that hearing, it's anonymised. So that's the best way to deal with confidentiality and data protection issues if the matter gets to a public hearing. So claims themselves, as we've said, tend to be brought in the employment tribunal, and an individual who believes that they have a claim can bring that claim whilst they are still employed. So that's an important point to note. and obviously by bringing that claim, again, protected from any form of victimisation. If the employment has come to an end, then they have 6 months from the end of employment to bring their claim in the tribunal. And that's an important distinction. We're used to thinking about 3 months in terms of most other statutory claims, but it's 6 months for equal pay. And as we've said, up to 6 years arrears of pay can be awarded, and the tribunal will also order that the pay inequality is removed. So if the individual still remains employed, they effectively get that pay rise going forward as well. And where there's a finding against an employer in tribunal, then the tribunal must order that employer to undertake an equal pay audit and publish the results of the audit. So that's a pretty compelling reason to make sure that you are on very solid ground if you're thinking about contesting an equal pay claim all the way, because it might not just be liability in connection with that claim, it could open up the floodgates to lots of other claims once you've done your equal pay audit. So that brings us on to equal pay audits and the extent to which they are desirable. And I know it's something that a number of my clients are grappling with at the moment. Is this the right thing to do for the business or not? Well, here's some guidelines. If you are thinking of doing it, I would suggest that in the first instance, you decide on your scope. Are you going to do a full audit of every job in the business? Or are you going to take a staged approach, site by site, or level by level in terms of your organisational structure? You might also want to think about who's going to undertake the audit. You might have internal and external expertise to think through who's best placed to advise on these issues. Obviously, I've mentioned the legal privilege advantages if you engage with lawyers to help in that process. You may also want to think about what data will be required. I've said see checklist. There's actually a really helpful checklist on the Equality and Human Rights Commission website where they talk about undertaking equal pay audits. So that's a useful reference point. And set some expectations and agree up front, you know, what does the board want to achieve out of this? Do we just want to know where the issues are, or do we actually want to do something about it and start closing off any pay inequalities? And certainly what I would say is, particularly in a large organisation, expect some gaps, because unless you've had a very, very controlled approach to setting pay within the organisation, the chances are, as we'll come on to, that a number of dangerous practices will have crept into your business that are going to have led to pay inequalities. So the next phase, once we've decided on our scope, and let's say we've decided that we're going to do every job at one particular site, we then look at who is employed in that particular site, and we decide who is doing equal work within that site. And from an equal like work perspective, we can probably make a pretty educated assessment of who's doing like work. Let's assume there's no job evaluation scheme in place, so that's not relevant. The only challenge we've got then, I think, is working out who within our organisation is doing work of equal value. And as I've said before, I think that's a very difficult exercise. It's one that even a tribunal doesn't really want to have to grapple with. So that's probably where you do need to be instructing an expert to have a look at the organisation, and they will effectively design a phantom job evaluation scheme, if you like. Now, to do that, your expert will certainly need access to job titles, job descriptions, but they may also want to interview employees. So we just need to think that through, because if this is a secret squirrel project in your organisation, then clearly having some pay consultant coming in and interviewing employees could set hairs running. Now, once you've identified who's doing equal work, you then want to compare some raw data of those who are in equal work groups. So group them all together on a spreadsheet, look at their basic pay, their total pay, because it covers contractual remuneration generally, and compare each element on that term by term basis to see whether there are any anomalies. And again, guidance from the Equality and Human Rights Commission here is quite helpful, which is, we don't need to drill down into this on a individual by individual basis. We can actually work on the basis of averages, both mean and median, within the equal work group, and look at it from males and females. And if that exercise throws up a difference of 5% or more between males and females on a mean and median basis within an equal work group, that's when the Equality and Human Rights Commission says you need to drill down into this and really start to look at individual comparisons. Why is there that material difference? And this is, I think, perhaps one of the most illuminating points in all of this. You need to just stop and think, have our existing pay practices and policies contributed to this in any way? And if you start to think of it, starting salaries, pay progression tend to be the biggest factors. Actually, it's those things which unwittingly can really cause significant pay differentials within an organisation. And if there's no controls over that, and decisions are devolved to local management with quite a bit of discretion, then that's when problems can arise. You then might want also to be thinking about whether genuine material factors which aren't tainted by sex discrimination exist, which could potentially explain the disparity at that level. And then, as a final step, if your equal pay audit does uncover a pay inequality, then you really do need to think about your action plan. How are you going to respond to this? And one obvious solution is, well, we'll start to provide equal pay to those who are being underpaid. We'll give them an immediate pay rise. That's great, but how's that going to be funded, and what's the wider impact going to be on the business of that? And also, pay, it seems to me, is often associated with status within the business. And if suddenly somebody realises that one of their colleagues has been given a pay rise to be paid the same amount as them, then they may suddenly feel that that's somehow affected their status. So we've got to think about the wider employee relations issues and how we're going to manage this process. We also need to look at those pay policies and practices which may have contributed to all of this and remove any risky or dangerous practices. I've just pulled out here a few examples of what the Equality and Human Rights Commission thinks of as risky practices. And it's things like, and we see this so often, lack of transparency. Do you openly talk about what people are being paid? Most organisations don't. Discretionary pay systems. A lot of organisations have those. Out-of-date job evaluations. That's a very common occurrence in my experience. Offering managerial discretion over starting salaries, as we've talked about, and relying on what the market says we should be paying someone. And the problem with that is that the market's perception itself might be inherently discriminatory, and therefore this whole market forces defence may fail if actually that particular market is tainted by sex. So, having identified our action plan and thought through how we're then potentially going to resolve pay inequalities, I think the final stage, I think I said the other one was final, but this is the final stage, is consider introducing an equal pay policy. We don't see many of these. I think it would be a bold organisation that had one, but certainly something to aspire to, and something I think that feeds, well, all of this feeds really well into future gender pay gap report. If you want to say as an organisation we are committed to closing the gender pay gap, and you can say you've gone through all of these processes and you finally concluded with implementing an equal pay policy, then I think that can be turned into a really positive message for the business and something to be shouted about in your gender pay gap report. Okay, that brings to a close the formal part of the presentation from me. I will just go into my questions section and see if we've had any questions come through. Well, I'm pleased to say that we haven't, which either means that everyone is completely bamboozled and doesn't know where to begin, or that we've covered everything adequately and left no gaps in this presentation. I prefer to think it's the latter. I will just hang on for another minute or two to see if any questions do follow through. But if you find this a difficult forum to raise questions and you would rather speak to me directly, my contact details are there, or of course speak to your usual gunnercooke advisor. Okay, at that point, as no more questions have come through, I am going to officially close this webinar. Remember, it's available for listening to again on the website, and look out for your invite to your next People Hour webinar. Thank you very much.